If you're injured in New York and just received a denial letter from the insurance company, what do you do next? This could mean the difference between walking away with nothing and your head and your tail between your legs, or getting the compensation you deserve. Because here's the real truth. A denial is not the end of the road. It's where a lot of the people want to give up. But this is where the rubber meets the road. This is where the real smart ones fight back and win. I'm Brett Harrison, New York State injury attorney, and today I'll walk you through exactly what an insurance denial means, why claims get denied, and a step-by-step guide of what you can do if your claim was denied. First, let's take a deep breath, okay? Ready? And let's read that denial carefully. It will state the reason your claim was denied. And there might be multiple reasons why you're denied. Knowing the why is crucial because it guides your very next steps. Here are 4 common reasons insurance companies deny claims in New York State. 1, missed deadlines. If you waited too long to notify the insurer or file the claim, they might deny it for lateness in New York State. You must file a no-fault claim within 30 days of the accident. 2, disputed liability. The insurer may argue about who caused the accident. If there's any doubt, the insurance company might deny or delay your claim while also attempting to blame you for the accident. And number 3, insufficient evidence. The insurance company, they may deny your claim because they say you haven't proven their driver was at fault for the accident, or that you weren't really injured enough in this accident. Now, let's go to number 4, policy exclusions or limits. Sometimes accidents can fall outside coverage due to an excluded driver or the associated costs exceeding the policy's limits. In New York State, basic no-fault PIP or personal injury protection coverage tops out at $50,000 per person. If your expenses go beyond that, oftentimes the insurer won't pay more without further legal action. Now, it's frustrating, I know, but a denial doesn't always mean the end of your claim. It just means we got to work a little harder. The insurance company isn't voluntarily paying up quite yet. That's not a surprise, by the way. Now, let's discuss what you can do about it. Let's take a quick real-life scenario because the reality is that you are not alone. It's not just you. It happens more often than not. Remember, the insurance company, they're a business. Their goal is not to have to pay. So remember, you're not alone. And so many people go through these situations. To make this real, let me share a real scenario I had with a client. Imagine you're in a car accident over in Brooklyn. Could be in Brooklyn, could be in any of our 5 boroughs of Long Island. While going about your day, another driver runs a red light and hits you in your car. You file a claim with their insurance company, expecting personal injury compensation and car damage to be covered. But then you get the denial letter. And you're like, what now? Why don't they want to pay? Now you say, let's look at the reason. The insurer says you were partly at fault because they claim you were speeding. And you're saying to yourself, that's BS. I wasn't speeding. They just don't want to take responsibility. Well, this actually happened to a real client of mine. Let's call her Sarah. Sarah was so stunned and pissed off and angry, as you can imagine, and you would be. The insurance company outright denied her claim, hoping she'd just go away, accept the result, and move on and just be basically angry and pissed off and just say, I don't want to deal with this, because that happens a lot. But here's the thing. New York state law is on Sarah's side. Even if she was slightly speeding, that doesn't bar her from recovery. New York is what we call a comparative fault state, meaning even if you're partly to blame, you can still recover damages. Now, they may be reduced based on your percentage of fault in the accident. In Sarah's case, we fought back, and we fought back hard. We gathered the traffic cam footage and witness information proving the other driver was mostly at fault. And this is the best part. And even if Sarah was, say, 20% at fault, she could still legally recover the 80% of her damages. Now, of course, we would argue that Sarah wasn't speeding and the cam coverage shows otherwise. But let's move on. Faced with this evidence, the insurance company had no choice but to correct course and pay Sarah the fair settlement she was entitled to. Didn't come easy. We had to push them, and they don't just roll over. You got to beat it into their heads. You got to stomp on them and keep going forward and pushing and pushing and pushing till finally they're like, okay, these guys aren't going to give up. Let's just pay them. Here's the key lesson. Don't let an insurer use blame shifting as an excuse. We all know about excuses. The only people that believe them are you, or them in this case. Even if they say you're partially at fault, you may still recover a substantial portion under New York's comparative negligence rule. Before we jump into action steps, here are 4 critical New York State personal injury basics to understand. Now, here's number 1. As previously mentioned, no-fault insurance, PIP or personal injury protection, New York is a no-fault state. After a car accident, your own insurance company pays for your medical bills and lost earnings, up to $50,000, regardless of who is at fault. That's why it's called no fault. But you must file your no-fault claim within 30 days of the accident, or the insurer can deny coverage for being late. There's always a but in these things if you haven't noticed. So remember, 30 days must be filed. No fault, it doesn't cover pain and suffering, just economic losses. Economic losses meaning out-of-pocket losses due to this accident. Now, number 2, serious injury threshold. To go after the at-fault driver for your pain and suffering, New York law says your injuries must be serious or your economic losses exceed $50,000. The term serious injury, that's where there's a lot of litigation, but I'm going to break it down kind of on the simple side. It has very specific legal definition. It includes things like broken bones, fracture, significant disfigurement, like heavy scarring, like if the glass fell, broke in an accident, and it scarred your head, for example. The loss of a limb or an organ. It can be significant limitation or use of a body part, function, or system. Or it can be any injury that keeps you from your normal activities for 90 or more days. If your injuries are within this threshold, you can absolutely file a liability claim or lawsuit against the other driver. I know this is confusing. This is very basic, and there's a lot that goes into each of these categories. But let's move on. Even if you are worried that you may not qualify to meet the serious injury threshold, please be sure to consult with a personal injury attorney for confirmation. Because you know why? This is what we do. We know how to find these things and how to get you within these categories. It's a lot for you to understand. Let's move on. Number 3, comparative fault. As illustrated in Sarah's story, New York State uses pure comparative negligence. This quite simply means you can recover damages even if you are partly at fault, as long as someone else was also at fault. Your compensation would just be reduced based on your share of the blame. For example, if you were 20% at fault, that means you get 80% of your total damages. Now, when you're going back and forth deciding fault, that's something we as the attorneys, we fight it out. We punch and you stomp on the other side, we keep at them. But let's move on. Don't let an adjuster scare you off because you weren't 100% innocent. That's what they like to try to do. Their goal is to beat you into submission saying, forget about it, I don't want to deal with this. Now, unless you were entirely at fault, you have the right to seek compensation for the portion of the blame that is not yours. Now, let's go to 4. And honestly, this is very critical. Filing deadlines, or what we attorneys call the statute of limitations. In New York State, in general, you have 3 years from the date of the accident to file a personal injury lawsuit. Missing that deadline, you are barred from a complete recovery. For the most part, you're going to be barred. I hate to tell you that. There are a few exceptions, but we're not going to get into that here. Just remember 3 years. So there are a lot of steps in the process that happen long before that, and some situations have shorter deadlines. For shorter deadlines mean shorter statute of limitation and notice requirements. For example, if a city vehicle or a town or municipal vehicle was involved, you might have to file what's known as an initial notice of claim within 90 days of the accident. And then you must have to file a lawsuit generally within a year to a year and 90 days. Bottom line, time is not on your side. So act quickly after receiving a denial. Don't just wait and procrastinate. All right, now that you understand the landscape, Let's get into the specific steps that you should take immediately after an insurance claim denial. Number one, review the denial letter. Read it line by line. So much is said in those lines. Your very first move is to read the denial notice carefully. Identify exactly why the claim was denied. Is the insurer saying you filed too late, that your policy lapsed? Are they saying that your injury isn't covered or not serious enough? The reason will dictate your response. Here's a little professional or pro tip, as we say. Make a note of any appeal deadlines mentioned in the letter. Some insurance companies give you a window, often between 30 or 60 days, to appeal internally. Don't miss that if it exists. Remember, read that denial carefully. Read it a few times, because sometimes you get annoyed after reading it the first time and you might miss something critical. So just read it, walk away, read it again. Number two, gather and preserve evidence. This is so important. Next, start collecting all relevant documents and evidence related to the accident and your injuries. Documentation, documentation, documentation. This includes accident reports, photos of the scene and damage, medical records and bills, witness statements, and any prior correspondence with the insurance company. If the denial reason was lack of evidence or disputing something, this step is so critical. For instance, if they claim you weren't hurt, make sure you have your medical records, again, the documentation, and doctor's reports, proving your injuries are related, that they do exist, they are real, they're causally related to this accident. If they say you missed a form or deadline, gather proof of whatever you did. You must submit it. Essentially, let's build a file to counter their argument. Their evidence will be the foundation of your appeal or your lawsuit. Number three, consult New York personal injury attorney. Honestly, this is often the game changer. Getting a seasoned personal injury attorney involved early can dramatically improve your odds. As a matter of fact, 80% of recoveries, or almost 90, between 80 and 90% of recoveries are generally when an attorney is involved. And generally, they're anywhere from, I can't even tell you how many times more than when an individual who's not an attorney and who's not skilled in arguing and collecting proof and data on your file, they get significantly more than if you did it yourself, even minusing the attorney fees and expenses. A personal injury attorney, like myself, will evaluate the denial reasons and quickly tell you if the insurance company is off base or, you know what, just like crazy. You're like, what? Are you kidding me? We handle these situations regularly and know how to fight back. We understand the insurance company's games and we understand why they're going to deny. We've heard it before. Why consult an attorney? For starters, most personal injury attorneys in New York State offer free, that's right, free consultation. So it doesn't cost you anything to get an expert opinion. When is the only time that you hear it costs you nothing? But that's true, it really does cost you zero. Secondly, if the insurer is giving you the runaround, which happens almost all the time, a lawyer's involvement signals that you mean business. The buck stops here. Enough's enough. Insurers, no, they can't easily bully or lowball you when you have legal representation. Why? We've been down this road before. It's not our first rodeo. This is what we do. An attorney can also make sure you meet all legal thresholds or enough of the legal thresholds. For example, confirming your injury meets the serious injury criteria to sue, collect for your injuries. We help gather additional evidence as needed, like hiring an accident reconstruction expert, hiring an investigator. These are the calls that we make. These are the things that need to be done quickly and right away. Why? Because evidence disappears, witnesses forget, videos are erased, whether it's ring videos and so forth. You know what I'm talking about. Must remember, keep urgency in mind. In New York, if your no-fault or PIP, personal injury protection benefits, were denied or cut off, an attorney or medical provider can help you challenge that denial through arbitration or litigation right away. And if it's the other driver's insurance company playing games with you and denying your claim, a lawyer can prepare to file a lawsuit to pressure them. You know, you got to clip that stronghold. You got to choke them. You got to beat them into submission sometimes. Sometimes you just got to keep punching and punching and punching, like knocking their head against the wall, literally. But that's just the way the game's played. Remember, their job is to not pay as much. The insurance company is a business. Okay. Number 4, appeal or challenge the denial. Almost every insurance company has an internal appeal process for denied claims. This usually means you, or ideally your attorney, will write a formal appeal letter responding to that's right, each and every reason for their denial, along with the supporting evidence. Remember, evidence is what's going to carry the day, not just your word or somebody else's word. What is the evidence? For example, if they denied your medical bills as not, quote unquote, medically necessary, that's the phraseology that they use, your appeal might include a letter from your doctor explaining why the treatment was necessary based on your injuries caused from this accident. Now, if it's a no-fault claim denial, your lawyer or medical provider might file for a no-fault arbitration. Basically what this means, this is just a quick process in New York State to dispute PIP or personal injury protection denials rather than a court lawsuit. If it's the other driver's insurer denying liability, your appeal is essentially a strong demand letter or simply proceeding to the next step, a lawsuit. The goal here is to give the insurance company a chance to reconsider and correct their decision without dragging you through the mud and into court. Oftentimes, a well-supported appeal can lead to a reversal or a settlement offer. Now, remember, our goal isn't to drag this out, but sometimes you got to put a little pressure and say, hey, we're willing to go the whole kit and caboodle. We're willing to go the distance with you. And sometimes they just fall into submission. So very importantly, make sure your appeal is submitted, obviously, within the stated deadlines. And you really should use a trackable method, meaning like certified mail, or when you file it electronically, that you have some type of stamp. This way you have proof that they, the insurance company, they received it timely. Number 5, file a lawsuit if necessary. If the insurance company still refuses to do the right thing after your appeal or negotiations, the next step is a lawsuit. Now, this is typically a personal injury lawsuit against the at-fault driver. In this case, their insurer will defend them. Now, in the case of your own insurer denying your first-party claim, like uninsured motorist coverage or no fault, you might need to file a suit against your insurance company for breach of contract or bad faith, if applicable. Lawsuits are a last resort, but they're sometimes necessary to get fair compensation and to put a little pressure on them to let them know, hey, we're serious. We're not just going to go away. We're going to be here for a long time. We're going to be gnawing and keep going like a dripping faucet. We just keep on coming. In New York State, as mentioned, you have up to 3 years to file a personal injury lawsuit, as long as it's not against a municipality or any type of state or county authority. Remember, it can be a lot less time in certain cases, but don't wait that long. Start the process. Lawsuits, they take time, and simply filing can often motivate a settlement or push a settlement. Your attorney will handle the heavy lifting, drafting the complaint, filing it in court, and pushing the case forward. Many cases settle before trial, especially when the insurer sees you have a strong case prepared. Most cases are won well before a trial happens. If you can show them the evidence and why you're entitled, they're not going to want to go to trial. Trust me on that. We've done this before. This is how you win, being prepared. Number 6, stay on top of medical care and records. This is a step people often overlook when focusing on the legal battle. You know what? You should continue your medical treatment and follow your doctor's advice, even if the insurance company isn't paying right now. Not only is this important for your health, but also documents the progression of your injuries. Remember, the most important thing is you getting better. Get that medical treatment. If you stop treatment because of a denial, the insurance company might argue, well, you weren't really hurt or that you got better quickly. Don't give them that ammunition. Let's just knock that out right from the start. No way, we're not going to let them use that against you. Don't let this happen to you. Use your health insurance or other resources to keep getting care. Save all receipts and bills. Remember, if your no-fault claim was denied, your health insurer should cover treatment through arbitration. That's a possibility. And you know what? Go through that medical treatment. That's why you pay those high premiums every month, year after year. Use it. This is what it was there for you to get better. So in the end, keep a journal of how your injuries affect your daily life. This can support pain and suffering damages if your case goes to trial. Number 7, notify New York State authorities if bad faith is suspected. This step is situational, but worth mentioning. Doesn't happen a lot, but it's another little hammer or bullet we can use. It's in our arsenal. If you believe the insurance company is denying your claim in bad faith or violating insurance companies' laws and regulations, you and we have the right to file a complaint on your behalf with the New York State Department of Financial Services, the DFS. For example, if your own insurer denies a valid claim without good reason, or the other driver's insurer is egregiously mishandling the claim, DFS oversees insurance practices. Now, while this won't result in immediate payment to you, it can put regulatory pressure on the insurer. And no insurance company likes to have the DFS on their shoulders. It's not a good look for them either. An attorney can advise if your case warrants a DFS complaint. So, in conclusion, fight back and protect your rights. A claim denial can feel like a punch to the gut, punch in the face. You know what I'm talking about. But remember, it's not the final word. Insurance companies in New York often count on people giving up. Do not let them. Apply some pressure. Put a little chokehold on them. You know what I'm talking about. You know the most important steps to take now. Understand the denial, get evidence, call a lawyer, appeal, and if needed, sue. All while minding those crucial New York insurance rules. No fault, serious injury threshold, comparative fault, and deadlines. Now, most importantly, act quickly. I can't say it enough. Act quickly and decisively. Don't procrastinate. Every day after denial matters. The sooner you push back, the better chance of turning that denial into a payout. Let's turn that frown upside down on you. You have the rights under the law, and you don't have to navigate this alone. If you're feeling overwhelmed, reach out to a qualified New York personal injury attorney who can guide you through this difficult and sometimes endless process and fight for you. You deserve it. So we just covered what happens if the insurance company denies your claim. But what's the secret to getting more from your accident insurance settlement? In my next video, I reveal 5 secrets to double your injury settlement. So check it out now.